Hello, this is your host, Mark Lieberman of the show The World According to Mark, coming to you through WPVM LP in Asheville, North Carolina, 103.7 on your dial, streaming globally on WPVMFM.org. And today we have a repeat guest. He's repeat because he's a pretty smart guy and he talks about interesting things. And that is Michael Maslanka, a professor, soon to be associate professor, appointed associate professor of law at the University of North Texas, Dallas College of Law. I think I got that right. So, Michael, thanks for being on the show.
It's a privilege. It's a privilege.
Good. Well, congratulations on your tenured position.
Thank you.
So, Michael knows and devotes himself to teaching and education of a variety of subjects of the law. But he caught my attention recently in an article that he published in the Texas Lawyer, which is a publication for lawyers. And I know that most of my listeners are not lawyers, so we're going to try to stay a little bit out of the weeds and describe things. But he wrote an article that had the byline, Cuomo case may be the catalyst to change sexual harassment laws. And then further, has the law concerning sexual harassment kept abreast of the societal change triggered by the Me Too movement? Or has it remained stuck in the pre-Me Too time warp? All right, that's a mouthful. So I'm going to stop talking and ask you, Michael, what was your motivation to sort of bring the issue of the Me Too movement as it pertains to Governor Cuomo?
There were two reasons. First, it was topical. It was in the news, and people in the public had a lot of questions about it. The second was this: as you know, the Me Too movement started a number of years ago, and there's always been in my mind a question that I wanted to answer: is the Me Too movement reflects culture, it reflects society. But is the Me Too movement synced up with the substantive law? In other words, the Me Too movement is kind of forward-looking. Is the law catching up with the Me Too movement? The law, as you know, as a lawyer, moves slowly and incrementally. And I actually did a study on this, and I teach it and I think about it. And what I found was that, by and large, the law is very slow to catch up with the Me Too movement and the cultural mores that are now saying harassment is wrong. Sexual harassment is wrong. It prevents an individual, both men and women, by the way, from reaching their full potential. But the law sometimes doesn't catch up in the way it interprets the law to achieve the goals that the Me Too movement wants to achieve. And that's what got me interested in it. And that's why I decided to think about it. And that's why I wrote the article, and it was published in Texas Lawyer.
So I think that's a great introduction. Let me just add a couple of thoughts of my own that I came to after reading your article and doing a little bit of research. And we talked about this before we came on air. As you say, Me Too movement is forward thinking. I guess it's safe to point out, first of all, that while the Me Too movement has gained a lot of adherents and has a lot of supporters, including a lot of folks in politics, lawyers and Congress and the like, not everybody shares admiration for Me Too. There's always, it tends to be that a progressive movement has some backlash. And some people feel that the Me Too movement has gone too far. And what you said, though, which is more important, frankly, is the judicial process is not an arena, essentially, where social issues are aired. The law is built upon statutes, constitutional principles, of course, and actual cases that come before the judge. So even accepting the fact that it's slow, it's also not the case that judges and lawyers are going to evaluate issues pertaining to sexual harassment in the same way as people who are in politics or people that are part of the progressive Me Too movement.
Yeah, I think that's right. It's not synced up. There's a complete and total, no, complete and total disconnect may be going a little far. But there's a disconnect between the substantive law, which someone is sexually harassed, quote unquote. They want a remedy for that. And the law is not always designed to provide a remedy. That's the disconnect, right? People think, oh, this is awful. This is sexual harassment. Something must be done. Damages must be paid. But the disconnect, and that's where the Me Too movement is, the disconnect is that the law puts brakes on that idea. The law has a fairly high standard for establishing, for instance, sexual harassment or a hostile environment. And so they're up here, the Me Too movement, and the law is sort of catching up a little bit. It's taken a while. It's doing it very slowly. Someday they'll be equal, right? But not now. Not now.
Well, I think my opinion is that where there is a sync up is between the Me Too movement and the law is the Me Too movement. One of its objectives, I would presume, is to motivate, incent, support women, and not just women, we know, but people in the workplace who feel as if they have been sexually harassed and not amounting to rape or some criminal conduct, who prior to Me Too and the positive publicity it's gotten, have been reluctant to come forward. They're still reluctant to come forward. Even this movement is at least a decade long, maybe longer, I'm not sure. So the fact that the Me Too movement has provided a push to people who otherwise might protest, as well as a sort of backup defense that somebody who comes forward and expresses what happened to them as a potential sexual harassment are not, and this may be a wish and a prayer, are not as likely to get stones thrown at them and to be dismissed out of pocket, so to speak, for having raised the claims to begin with.
Yeah, and that's a good point. When they raise the claims, it's very interesting. So what they have to prove in court are many things. The standard that's been set up by the Supreme Court is that the plaintiff, again, a man or a woman, but I mean, it applies to both. Well, I may lapse in speaking about women, has to prove that the environment, the hostile environment, is either severe or pervasive. What does severe mean? Is it once? Is it twice? I don't think so. If it's bad enough, if a terrible slur is used against a woman, maybe once or twice, the worst slur you can imagine, that may be sexual harassment in the mind of the Me Too movement, but the court is not going to say there's a legal remedy here. And then the question about pervasiveness. Maybe it's not severe, but does the sexual harassment happen all the time? But if it happens all the time, if it's simply indignities, impoliteness, you're not taking care of my feelings as an employee, the law is not concerned with that. Society may be, and they maybe should be. The law is not concerned, and those kinds of cases get bounced out.
Okay, so moving ahead here then, first of all, you might want to educate our listeners in terms of what are the elements of sexual harassment, and might also want to distinguish between a criminal case of sexual harassment and a civil case. And then we need to start talking about the Cuomo case, which is what your article had featured.
Sure. So the elements so there are a couple of different kinds of sexual harassment cases. One kind was called a quid pro quo, and that's you sleep with me and you get a promotion. And conduct in that case is not consensual. It's unwelcome. In those instances, and then something bad happens to the employee because she refuses to have sexual relations with the manager. We'll talk about managers in a minute. So that's sort of this quid pro quo. The other sort is a hostile environment. And that's where the workplace is so saturated with hostility towards women, not necessarily even dealing with sexuality, but hostility towards women. Women don't belong in the workplace. Go home, have children, be pregnant, be fruitful and multiply, but get out of my workplace. That too is a separate kind of claim. And in those kinds of claims, the damage is that the woman or the man doesn't feel or isn't allowed to reach their full potential as a human being and as a worker, more importantly, as an employee. So those are the sort of two kinds of claims that 99% of the time, those are where the claims fall. And with Governor Cuomo, from what I can decipher from the report, it's more of this hostile environment claim, right? So that's the civil component of this. Now, there's also can be a criminal component. The criminal component is sometimes is that there's physical touching, right? It's assault and battery. You say you're going to touch someone, it's not consented to. We'll talk about consent in a bit, but nonetheless, it occurs. You grab someone's buttocks, you touch someone's breasts. That is a crime. It can also be civil liability, but it can be criminal liability as well, because in every state there's statutes against assault and battery, and that's what they're investigating. Well, soon to be, I guess today maybe he's resigning. Soon to be former Governor Cuomo. So that's the criminal aspect of this, and more and more people are going to both. People who believe that they've been victimized. And remember, men are also covered under this. It says in the statute, Title VII, because of sex. It doesn't say because of females. You're treated differently. You're exposed to these conditions at work because of your sex, because of your gender. But the devil, as you say, Mark, is in the details.
So something I just got from what you just said is the line between civil and criminal conduct seems to go along the line of what you say versus what you do. So now there were elements in the 165-page report going through 11 victims and complainants in which Governor Cuomo was alleged to have touched, but the touching, which would make it a criminal case or maybe a good criminal case, would be something more aggressive, presumably, than that. And I don't know if that is a hard line or a gray line between, again, merely, and I use the word merely, saying because in years and years past, what you say is not generally criminal. We had the whole issue with the insurrection. You can say a lot of stuff apparently, but until you cross the line into promoting violence, it doesn't necessarily take on a criminal element. I don't want to get into that, but do you follow what I'm saying?
Yeah, absolutely. So what you say, and it's interesting you say this. Years ago, here in Texas, there's a case called the DeAngelis case. And the complaint was that things that were said, right, about women and their place in society should not be punished. Why? Because they're protected by the First Amendment. And that issue has never really been resolved. But it is a defense, right? In both the criminal context as well as the civil context, to say, yeah, I said these terrible things. Or maybe these things that are not politically correct. Women shouldn't be working here. Women are dumb. Women are stupid. That's an opinion. And the government, through the law, cannot censor that opinion. And so we haven't really seen a lot of it, but the First Amendment is always there as a possibility for defense. I would simply say this about the crossover between civil and criminal. And I give the Me Too movement credit for this, credit for changing this. For the longest time, to have a civil claim of hostile environment, the courts seemed to repeatedly focus in on touching. Was there unwelcome physical contact? What was the nature of that physical contact? Was it threatening to the person who was subjected to it? And finally, a few years ago, courts started to tease out that idea and to say you could have a hostile environment based upon sex and be civilly liable without unwanted physical touching. Because employers, I used to represent employers for many years before I became a law professor 6 years ago, would argue, well, nobody got touched. Right? It was just language, it was just opinions. And the court said, you know what? You don't need to show touching with your plan. If it's such an environment that is so hostile, that essentially prevents you from getting your job done at work, then it's going to be what's called in law, cognizable, a recognized claim.
But from your article, and I'll let you speak to this, it does seem as if the issue of, verbal versus, physical behavior, touching, still creeps in to, the responsibility on the part of the plaintiff to prove his or her case, such as the courts decided a case where it seemed like the court was really saying this was a case where a woman was working in a so-called blue collar environment, and there were the usual blue collar jokes and calendars and what sometimes is referred to as, quote, locker room talk, and the court recognized that some of that would not is sort of part of the deal that a woman would have. It sounds offensive to me, but that a woman would have if she goes to work in that environment, that she shouldn't be turned off by it to the point of feeling like there's a sexual harassment issue if she went to that workplace knowing the context of it.
Yeah, you raised an interesting point and a good point. There are some cases, and I cite one, the Rabideau case, where the courts say, male judges, by the way, let me just hasten to add, you never get an opinion like this from a female judge, but male judges will say, you know what, and I think in this case I mentioned in my article, it was an oil refinery, it was a blue collar environment. They basically said, I'm going to translate this. What do you expect? The F word's going to be tossed around. There are going to be pinups. There's going to be naked, women naked in Playboy or Penthouse or whatever these magazines are. There's going to be language that is derogatory towards women. And you know what? That's part of the deal. And what these courts say, they cloak it, though. They cloak it in legal language. They cloak it. Well, you assumed the risk. You consented. You consented to this kind of environment, and therefore you don't have a claim. Well, from a moral standpoint and from a legal standpoint, that doesn't hold up. Let me just talk about a legal standpoint. What if you're a Black person and you go and you want to work at a company that has had racism and issues for a number of years, and you're the first Black employee there? Is a court going to say, well, you're Black, you know what you were getting into? Here's a bunch of terrible people. They have a history. Read it in the newspapers. You consented to racism. It doesn't work in that context. So why should it work with a woman? It works. It works. I mean, it works in the minds of some. I don't think this is legally sound. You know why? Because she's a woman. It is unfortunate, but it's sort of like, well, why did you dress them? Well, of course you're dressing in a sexy way. You asked for it. And that is offensive morally. And that's not a political statement. It simply is. It's offensive legally because it's a different standard than you would apply to a Black person. And it doesn't make any sense. And it's a terrible argument to make. A jury will, I think, if this argument is not handled correctly, I don't think it should be made. Cuomo sort of tried to make it. It's going to blow up in your face if you're an employer. It's a morally bankrupt argument. But there's still cases in the books that have never been overruled, never been set aside, and is still used. And it shouldn't be.
So again, going back to your first or statements about Me Too being ahead of the judicial system, and me suggesting that Me Too is pushing hard on victims to come forward and trying to create an atmosphere where some of the more baseless defenses, including those that Cuomo raised, are hopefully on their way to being illegitimate from a legal standpoint. And I think that's part of what you were trying to get to in your article.
That's right. I think the Me Too movement's done a lot to getting rid of this physicality requirement, to this grabbing, right? In fact, we're here in the Fifth Circuit in a case several years, maybe about 4 years ago. The Fifth Circuit said, you don't need the touching. You don't need the grabbing to prove a hostile environment. And so I think the Me Too movement has helped sensitize people and judges to that issue. Give them all the credit in the world for that. But this notion of consent is still so ingrained in our culture that she consented to it. That one's going to be a hard one to eradicate. Governor Cuomo, former governor, he sort of raised a trial balloon in his first speech, right? It came out of nowhere. He said, well, we work in a demanding environment here. And I try to lighten things up. But, I think he said something, I'm not quoting him directly. This is a 24/7 environment. I thought, well, why is he saying that? And what occurred to me is it's a trial balloon. He raised a trial balloon to see how it would go over, because I think he may be using that as some sort of consent defense. So I don't know. It's a bad argument. And if I was representing him, I from what I can tell, I think he's a very good advocate and effective lawyer representing him. I would stay away from it. It's not.
Evidently, he learned his lesson, at least in part, because he withdrew. But let me again introduce Michael Maslanka, who is a tenured professor now, soon will be, at the University of North Texas at Dallas College of Law, contributor to many publications, including Texas Lawyer. And we're talking about sexual harassment, sometimes I get that both ways, the Me Too movement, and how things look in the light now that has been thrown on ex-Governor Cuomo. And we're talking about the fact that even though the Me Too movement has been effective in resensitizing or sensitizing people who presumably weren't before, and setting up some potential boundaries about allegations which may not have a legal impact and may also just be embarrassingly ridiculous, as some of Governor Cuomo's statements have presumably come back to haunt him. But some of the challenges, and I wanted to bring up again in terms of one of the elements for proving sexual harassment on a civil level, is you have to show damage. And that seems to me to be another place in which the sort of pre-Me Too movement can insidiously insert itself. I wanted to see what you thought about that.
I think that's right. So the idea is, well, where's the damage? If it's a hospital, so you're eligible for a promotion. You don't get it because you don't sleep with me. So you don't get the promotion. So that's tangible, right? A hostile environment, by contrast, how are you harmed, right? What are you harmed? It's very perverse because the concept is that you were unable to do your job to the best of your ability. That was the harm. Well, what if you're a strong person, a strong woman, a strong man? What if that's the case? No remedies? So courts are starting, and there's a fairly recent case saying, merely affecting your potential to be better. Let's say you're a salesman, and let's say you're an excellent saleswoman. There's all kinds of sexual harassment, it's hostile environment, but you're an A salesman. A. Well, if this harassment stops you from being an A+ saleswoman, or it impedes your growth into being an A+ saleswoman, that's enough to show the damage that you quite astutely pointed out. That'll be enough, because the law should not be so perverse that someone who's mentally tough should not be protected. And also in terms of damages, there may not be any out-of-pocket damages, but the law allows for what are called compensatory damages. And compensatory damages entail, there's something called mental anguish, but they cover much more. They cover loss of enjoyment of life. Right? And what very effective plaintiffs' lawyers do, represent employees, what they do is they paint a before and after picture. I have a new book that actually came out not long ago, and I'm going to talk a little bit about this. This is my life before the hostile environment. This is my life after the hostile environment. And that's effective because it says, I'm always having to look over my shoulder. I'm always having to walk on eggshells. I don't enjoy my life the way I used to enjoy my life, or hang out with my friends. And I'll simply mention this too. And I think this is true. It goes back to consent. It always kind of twists together as a process. In my experience over being 40 years as a lawyer, women often will participate in the unseemly joke.
The banter.
The banter. Why? Because they want to be accepted. No one wants to be the odd person out. And so what we sometimes perceive as consent is simply a woman's way of surviving. Can't put it any more directly than that. And so that's why, both from a legal standpoint and just a moral and sociological one, simply by participating doesn't mean that they're consenting. Now, there may be exceptions to that. She may initiate it, for instance, not just once, but several times. So there's a lot of gray in the law, but you cannot assume that just because she participates, she's consenting. There can be other reasons that you have to look at.
You know, I think there's another lens, and I'm not sure whether you covered this in this article or covered it in some other publication, but it has to do with the, quote, reasonable person versus the reasonable woman concept. Talk about how that gets into the calculus of whether somebody has effectively put forth a case, a credible case on sexual harassment.
Yeah, that's a really good question because it's crucial, right? So let's say there's a lawsuit, and let's say it goes to the jury. The jury's given what's called jury instruction to decide whether the environment was objectively hostile and subjectively hostile. Would a reasonable, would a person looking at it objectively think it was hostile and would stop the person, the plaintiff, from getting her job done, right? And subjectively, did she or he subjectively believe that it was a hostile environment? Well, they're given jury instructions, and the courts have not agreed on this. So some courts say, you know, ladies and gentlemen of the jury, look at it as a reasonable person. Would a reasonable person be offended by what's going on and stop, be frustrated in their ability to get their job? Now, minority of courts, and I give credit to the Me Too movement for this, right? You know, for their focus, they say, no, that's not right. It's the reasonable woman standard. And that's interesting. Of that concept, actually, was a throwaway line in an opinion by the late Justice Scalia. It was before the Me Too movement. He talked about a reasonable person. I think it's what lawyers call victim. I think it was just thrown in there. But now it's been seized. And our court here in Texas, our appeals court here in Texas, a few weeks ago, didn't say it was victim. They said it's the law. It's the reasonable person in the place of that plaintiff. What I take to mean as a reasonable woman. Would a reasonable woman feel offended? You know what? I could be, I'm not a woman. I haven't gone through their experiences. And what this means is all kinds of evidence about her background, the history of discrimination against women, all of that would become then relevant in a trial. All of it. A reasonable woman standard unlocks that evidence. Reasonable person, it's all irrelevant. A reasonable woman, from what a woman goes through, then if that's the standard, if that's what the jury has to measure the facts against, all this stuff comes in. All this stuff about women and subjugation, all of it. And that can be devastating to an employer.
Well, hopefully we'll get to a point in which the distinction between a reasonable person and a reasonable woman there is no distinction, because a reasonable person should be able to relate regardless of his or her gender.
Yeah, I've often thought that, of course, I'm not king of the, even though I'm tenured, I'm not king of the universe. I live in my little office here. I always like the idea of a reasonable human being. All right, I mean, we're all human, right? We're humans.
Well,
reasonable human being.
I'm old enough to remember in law school that we always talked about the reasonable man, or the reasonable man in the Clapham, and I'm not sure I'm pronouncing that right, omnibus, which was the British standard for the reasonable man, because I don't think we had Clapham omnibuses here, but in any event. So again, these issues have to be teased out. We talked about several of them. Let's move a little bit further into this now. Again, I think the societal norms about what constitutes reasonable behavior versus harassment, if only a tenth or a third of the allegations in the 165-page report held up, to me that would be enough to find ex-Governor Cuomo civilly liable for his actions. But of course, I have to temper that thought, introduce a little politics here, is because we went through the Trump administration, and we went through allegations of, in some cases, more sinister conduct on the part, and I must say, in fairness, allegations, much more sinister conduct and physical contact by the ex-President Trump.
Yeah, I mean, that's true.
My point there is simply that if you were trying to account for where the Me Too movement has pushed us, and put us in a position where we can start acting more fairly in the adjudication of these things, we look at the fact that Governor Cuomo, for various reasons, decided it was better to sit down. We still have to factor in all of the sort of bad precedent associated with an unprosecuted ex-president of the United States, who presumably, as I said, according to the allegations, was engaged in much more nefarious behavior. So what gives there? Because he was the president? Because a lot of issues.
You know, I'll be candid. I don't know. It puzzles me as well. I really can't explain it. I mean, I don't know. I don't understand the dynamics of it. because the accusations against former President Trump were much more serious. I mean, it's accusations of Governor Cuomo, former Governor Cuomo, are serious, don't misunderstand, but they're much, much more serious. And it could just very well be that, justice will be catching up in some sense with President Trump. But I really, I don't know.
Well, I would say again, and don't want to bury this topic, but I would presume that maybe Governor Cuomo thought he could, quote, get through this, slide by it, because Trump, who again was alleged to have committed worse acts, did. So he felt, and look, I think it was one of the complainants, I think number 11, who never has been named, a trooper, who was, according to the story, she was accompanying him to a signing ceremony for Governor Cuomo's authorizing a law that was tougher on sexual harassment. And then she gives information to the Attorney General saying she herself was harassed. So
I recall that, and there was some touching in that. I would make this observation about the contrast between Cuomo and Trump is that Trump's the allegations against Trump don't deal in the workplace. They deal with third parties, right? Reporters or whomever. Cuomo strike more to home to people. This is the workplace. And I think maybe what the governor forgot, I would take a generous view of this, is the power differential. Yeah, he's the governor, but it exists all over. There's different power dynamics, and you have to understand them between a manager, an executive, a law professor, an employee, or a student. There just is. So, by way of example, there's an accusation that one of his subordinates was sexually assaulted. The Governor Cuomo said, well, that's somebody close to me. He didn't say maybe it was one of his daughters. And so I have a lot of experience with that. So he decided to play counselor with it. And he asked her questions. He said, well, somebody close to me was sexually assaulted. And then he decided to ask all these questions about being gay, doing sex with older men. Even if those were well-intentioned, you're the boss, you're not a counselor. You can show empathy, concern, you need some time off. They're seeing a therapist, maybe you need some time off, but you can't intrude. You simply can't. You're someone in their 60s. She's a young person in her 20s. And the dynamic is such that even if you're not thinking exploitation, the idea is it could lead to exploitation of an unfair nature. And you're not a therapist, Andrew. You're not a therapist, you're a lawyer.
I think you raise a really important distinction now, sort of clarifying it. As bad as the allegations may have been against Trump, as you correctly pointed out, most, if not all of them, didn't occur in connection with him managing a workplace, because frankly, he didn't really manage a workplace. But workplace environments are obviously very important. And we've been doing things some things for the last 40 or 50 years to make sure that people of color get hired and don't feel intimidated. People who identify with different genders than they were born with don't have a tough time, and so on and so forth. And as you say, there's fairly well explicit rules. Every company, every government agency has a handbook on how you're supposed to behave in a workplace and what happens if you feel that there's a problem. But again, that also poses some constraints, which is, and I don't know what was the case with these 11 complainants, but the question then arises is, if you felt that you were being harassed, what did you do about it? Who did you report it to? And that's again, a fuzzy analytical area because it brings up a lot of issues like, did you feel like you could report? But you might
Yes.
want to speak to that.
Yeah, that's an interesting point. So the Supreme Court of the United States several years ago said that an employer, if a manager, a true manager, right, somebody in authority, takes an adverse action against them, and doesn't promote them or fires them because they don't want to have sex with them, then the employer, if the jury believes that to be the case, is automatically liable. But there's this whole other area of this hostile environment that we were talking about. So the Supreme Court said, you know what, if you as the employer set up a reporting system to say you're not going to be retaliated against, if there's an issue, we want you to say, report it to HR. You don't have to report it to the manager above you if that's the one doing the harassing. And there have been a lot of cases that were dismissed where the plaintiff said, I didn't report it because I was afraid something bad was going to happen to you. Now, the Me Too movement has actually had an effect in this area. It's in the northeastern part of the United States. So there's a federal appeals court that covers Pennsylvania, New Jersey, so another state. And what the court said was this. They said, you know what? There may be a really good reason she didn't report it. And we're not, and if there is a good reason, other people have been fired. The only thing between me and the street is this paycheck. If there's something that can go to the jury and the jury can say, you know what, she acted as a reasonable person or as a reasonable woman in not reporting it, then we're going to not penalize her with automatic dismissal of her case because she didn't report it. We're going to let a jury figure out, will she be reasonable, not reasonable, should she report it, or should she not report it? That all came about because of the Me Too movement. This Third Circuit case that I mentioned, I think at the end of my article, is a big deal, right? Because it chips away at this very powerful defense that employers have. And I did some research on it. It hasn't been picked up in the rest of the country yet, but I think that's just because it's not well known. If it's picked up in the rest of the country, then we'll see a different dynamic of terms of these cases being dismissed. Because if you're harassed and there's a policy and you don't report it, you're pretty much DOA. Your claim is DOA. That's it. The Third Circuit now has breathed life into this case.
Well, and one can have some sympathy for the notion that at a minimum, a party should report, because the concept of reporting in both case law and policy was really a way of, again, flushing things out might be the right word, and creating an obligation on the part of the employer to have a process where a victim would not feel threatened by making her claim.
Yeah, and that's right. So I'll just build on that a little bit. The idea is tell the employer what's wrong so I can fix it. Now, maybe that's a sort of idealized utopian version of the way things should work, but we have to have aspirations to make the law better, and that's an aspiration.
And I can imagine, but let me just, again, for those just tuning in, hopefully, or for those who forget, we're talking with Professor Michael Maslanka, a professor of law at the University of North Texas at Dallas College of Law. We're talking about sexual harassment. We're talking about the Cuomo case, and we're talking about sort of the bar for victims to get their claim heard and get taken seriously. But I can imagine a case where an individual or employer has responded very, very, very nicely, so to speak, or very well to harassment claims. and vetted them out and so on and so forth. And then in a particular instance in which somebody did not come forward, did not have the opportunity to determine whether or not there was a hostile workplace, and that being used as favorable evidence to the employer.
Yeah, yeah. I mean, that's absolutely correct. Although I will say this, if I could, because I'm sensitive to another issue here, and that's people who are wrongly accused, or where there's a disproportionate response by the employer. So some employers think, got a complaint, I'm going to solve this. As Stalin said, no man, no problem. And they fire the man. They just fire him. They don't listen to what he has to say. They don't conduct an investigation looking at his point of view. But they listen to everything she says. I'm assuming it's a woman complaining. It can be different. If that's the case, then the man has a claim of sex discrimination because he is similarly situated. There's an accuser and an accused. And if the accuser gets better treatment because of her sex than the accused does because of his sex, and there's a rush to judgment, that is a claim on the face of it for discrimination. Because false allegations are made, accusations that are false are made. That is altogether possible and true. And so I think any response has to be what I like to call proportionate. It's got to be proportionate to the issue at hand. I'll just say one other thing. Employers make a terrible mistake. Let's say they investigate, they can't figure what's going on. So they tell, let's say it's a female. They say, well, if there's an issue, come back and let us know. It doesn't mean an issue. No. You go back, you say that, but then you go back to the person who complained periodically. Is everything okay? Anything you want to tell me? Any issues that have arisen in any way at work? You take that proactive stance and you'll find out what's going on. And if you're later sued, that's a wonderful defense because you say you don't want harassment, but as my mother used to say, if you say something is important, treat it like it's important. If you say you don't want harassment in the workplace, then treat it that way. And going back to the person who complained, saying we couldn't figure it out, I'll check in on you every once in a while. Is that okay? I want to make sure things are fine. That's living up to your promise. That's living up to your aspiration.
Very good. Well, let me move to another area. Excuse me. I wanted to just get your views on, and that is the evidence rules as they pertain to introducing information about an alleged victim and information about the alleged perpetrator. And there seems to be a little bit of a dichotomy there. I don't want to get too much into the rules of evidence and rules of procedure, but I think there's some important issues there to probe. So specifically, there's a rule, there's an overall rule of what kind of evidence can be introduced into a case. You can't say not all information is relevant. And then there's information that's relevant, but is considered to be prejudicial. We've all watched television shows where a lawyer stands up and says, I object, not because the information is not potentially relevant, but because it's so disparaging. I don't believe that evidence should be introduced, and the jury's excused and the lawyers fight about it. How does all that play into what we're talking about here?
So this is pre Me Too movement, right? So back in 1994, there was a rule of evidence called Rule 412. And it originally started in the criminal context because what would happen, defense attorneys representing their clients, they would defend their client by putting the complaining witness, the complaining woman on trial. Well, tell us about your past. How many people have you slept with? What have you done? Have you ever, been a call girl? All this stuff, right? It was unrestrained. And so the idea was, we're going to limit that. Is that you cannot put the victim on trial simply because she may have had sexual relationships with a number of people, right? Now, there are all kinds of nuances and how the rule is interpreted. But the Congress decided to apply that rule to sexual harassment cases. So sometimes a lot of lawyers don't know this. So they're defending a sexual harassment case and they go, oh, wow, she's a loose woman, quote unquote. She has sex with a lot of guys, and they think that's relevant to the case. And they simply try to offer it. That violates the rule. You get into deep trouble. If that's the case and you want to put that evidence on, which I think is strategic evidence, put it, you got to go to the judge ahead of the trial. You got to ask for a special hearing. You have to give the judge the evidence. It's not made public. And then a hearing is conducted as to whether this evidence is going to be excluded under what we call Rule 412 motion. Because the issue at trial is, was she sexually harassed in violation of the law? Not for conduct. Now, there are certain exceptions. If she, for instance, was constantly initiating jokes. If she was the one, for instance, that you had to tell her to be quiet, don't do it anymore. That's different. But that's why we have judges. Right? That's why we have case law. But 412 is very powerful. And it stops the person who's the alleged victim from being put on trial and focuses the decision maker, the jury, on what are the real facts and what happened in this instance. Now, there's a dichotomy, as you point out, because there's Rule 415 and there's Me Too evidence. You see it in the Bill Cosby case. You saw it in the case of the producer.
Weinstein.
Weinstein, yeah. Is this Me Too evidence? Well, you could bring out 10 women who claim that they were harassed by the same guy. Isn't that a double standard? And I think it is, and it bothers me because just as the woman has a right, so does the man who allegedly harassed her or criminally assaulted her. And my objection to this has always been, it's not fair because you get into 10 different little trials, right? Every person says, well, this happened to me, this happened to me, this happened to me. You've got to defend each and every one of them. And the jury loses sight of what they're there to determine, which is the guilt or innocence, the liability or non-liability of the person being accused. And that was argued in the Cosby case. It was not decided by the Pennsylvania Supreme Court because they decided to release him based on other arguments. So they never reached the argument about Me Too evidence being unduly prejudicial. But it's going to happen. It's coming down the pipe.
I mean,
the next big area of litigation and of controversy.
I mean, I can see sort of an argument why the past conduct of the alleged perpetrator is relevant, obviously, because again, typically the types of activity we're talking about, whether it's rape or sexual harassment or whatever, there's no eyewitnesses. So in the absence, it's a he said, she said situation. So it's the law has a hard time with those types of issues, it would appear.
But if it happened, by the way, if it happened in the same workplace
Mm-hmm.
or the same temporal period of time, that evidence is going to get in. But if it happened at a different employer, right? If it happened not in the same temporal time frame, in the same year that the plaintiff was allegedly harassed, if it happened 4 years ago, it's attenuated, right? And in those cases, it's unfair.
And we've had it goes to the theory of just because somebody robbed a bank 5 years ago doesn't mean he robbed this bank at this particular time. And I guess most lawyers understand that, and not the general public generally doesn't see that as clearly and distinctly. So, well, we just have a few more minutes left. I think there's another way in which the Me Too movement gets somewhat involved in this process, and it's not prior sexual conduct, but again, it has the issue. It's the issue of consent and the extent to which a woman or a man invites the activity by what she says, how she dresses, her conduct, and so on and so forth. And I think the Me Too movement has tried to put all that behind. Has that been successful, and is that the right approach?
I I think it should be behind us. I think though that I would have a different approach. And when I was in practice, I don't practice anymore. But when I would advise clients, and I represented corporate America, I would tell them, you have to get an anti-harassment policy. I understand all that. But in addition to that, have a standalone professionalism policy. We hired you because we expect you, no matter what job you do here, to be professional, to treat our clients and our customers with professionalism and courtesy, and to treat your coworkers, whether they're above you at the same level or subordinate to you, with professionalism and courtesy. That goes to your language in the workplace. That goes to your manner of dress. We want a professional work environment. And I think too often employers get all worked up about, well, was it severe or was it pervasive? Look, you got to have that. I get it. I understand it. I was a lawyer. I understand. I just don't know. Have a professionalism policy. And people, if you explain it to them in the right way, you appeal to the angels of their better nature. They will aspire, by and large, to be the professionals that you believe them to be. And a lot of this other stuff will go away. People say, well, I have a right to dress the way I want to. I have a right to. No, you don't. No, you really don't. You don't have a right to wear a certain kind of clothing. You work here. A condition of employment is to be a professional. This is not a professional dress. Period. End of story. You don't have that inalienable right. You have inalienable rights, but they don't extend to unprofessional clothing, by way of example. Don't do it. And I think a professionalism policy goes a long way.
Well, go ahead.
A friendly,
Recommendation.
Shakespeare has a great phrase in As You Like It. Friendly to your ear.
Yes.
I must tell you something friendly to your ear. Friendly to your ear. Don't wear it.
It's not a legal edict. Well, we're going to have to leave it there. Thank you, Michael Maslanka, professor,
Sure.
for this enlightening conversation. And I'd like to have you back again. There's more we can discuss. We can talk about workplace issues like wearing a mask, but that's for another time. So thank you. And I want to thank my producer, Focus Solutions, Shelley Lieberman. And again, we'd love to have you back, Michael.
Sure. It's a privilege always. Thank you.
Thank you.